Good afternoon, Your Honors. Len Garza from the firm Sandal and Zayat, appearing for Plaintiff Appellant Federal National Mortgage Association. We're appealing a decision after a traverse hearing at the below trial court.
Counsel, we know what the case is about. Go ahead, please.
Thank you. So we're appealing the decision, and really the analysis stops here.
Let me ask you, did you have a process server testify at the traverse hearing?
We did not, Your Honor.
So you didn't have the process server, you didn't have the process server's logbook, any of that evidence that is usually presented at a traverse?
Right. So what happened is a different firm was representing my client at that time, and they subpoenaed, it's not part of the record on appeal, but they subpoenaed the process server.
Well, if it's not part of the record on appeal, then I can't hear it. The question is what happened at that traverse hearing that the court presided over.
But that's why, so there wasn't the...
It wasn't. The court had to make a determination on the evidence before the court.
Yes.
There was none.
Correct. Right, but our position as well is that this shouldn't even have been a traverse hearing. This was in the 2009 action, but much of what was covered in the traverse hearing were facts related to the 2014 action, which wasn't even before this particular assigned judge. That was before
You didn't oppose the consolidation portion. There was a branch of the motion to consolidate the 2014-2016 action. There was no opposition to that, right?
I mean, I think you actually had also moved for consolidation at some point.
Possibly. I don't recall whether our client had, but either way, Justice McMahon didn't address it at the traverse hearing, so according to the cases in our reply brief, that branch should be deemed denied and respond. Yes.
Just so I'm clear, there are two foreclosures: the 2009 action, then there's a 2014 action. The 2009 action was against Mr. Morales, which it turned out later on that action had to be dismissed because he no longer owned the property. He had transferred that property to Mr. Cohen.
Correct.
Right? So that only, I mean, as a matter of law at that point, I mean, you can't go on with the 2009 action. So the 2014 action is the only live action left, and that's the one where you had a traverse hearing on for Mr. Cohen, the defendant, right?
Well, the action against Mr. Morales was dismissed as against the 2000.
Yeah, I got that, right. So the only live action left, the only live foreclosure action left was against Cohen.
Incorrect. There are other defendants in the 2000.
Well, I know, but this is what we have in front of us. I mean, we're only arguing about Cohen. We're not arguing about the other defendants, right?
Right.
Okay.
But either way, this traverse hearing was in the 2009 action. Judge McMahon, per the IAS, was assigned the 2009 action. She dismissed the 2014 action, a completely different action, which she was not assigned to. And based on that, nothing else should be considered. Now, I can go into how the actual substance of the decision didn't support the decision she ultimately made, but all that should be moot because she made a decision to dismiss a case that she wasn't even assigned to.
Yeah, but there was no prior conflicting ruling from the previous judge on that particular action. It's not like she did something in contravention of another judge's order or of anything else. She dealt with what was before her.
No, she didn't. She dealt with an action completely separate that she wasn't
assigned.
assigned.
The other action, there was nothing conflicting. There was no other judges. You're saying it wasn't assigned to her. She wasn't the assigned judge.
Correct.
But there was no conflicting decisions rendered by the judge who you claim to be the assigned judge. There was nothing that she did in contravention of somebody else's order.
There doesn't have to be. The fact that there was a 20... Oh, I'm sorry. Go ahead.
I was going to ask what you have that supports that.
Sure. I mean, the case law and the supply brief, just the fact that there is a separate action, the 2014 action, that's being presided over and assigned to per the IA system by a different judge.
I believe that's only where there's a conflicting order or there's some conflicting determination. There wasn't one here.
Respectfully, Your Honor, that's not how I read the cases. I read it, look, the fact that there is a separate action, end of story, one action, one judge. There doesn't have to be a conflicting order.
All right, thank you. You'll have reply time.
Thank you.
May it please the Court, Mark Anderson, Bowman, and Zalewski for the respondent. As Your Honors have indicated, at no point during the Travers hearing was there any testimony from a process server, nor did anyone ever appear for the process server's company. As a matter of law, that would indicate that they have not sustained their burden in the process.
Could you address the other issue, just because it is sort of somewhat of an unusual issue? Judge McMahon was assigned the 2009 case. It wasn't dismissed, even though both sides, it seems to me, from what I could read, moved at some point to consolidate the actions. Nobody ever ruled on consolidating them. So the 2014 action was at the time assigned to somebody else. And when the judge had the Travers hearing, she said, after oral argument, the other foreclosure action in 2014 is hereby dismissed, even though it was on, she wrote it on a gray sheet. I know it's white here, but I know it's gray down there, with the index number of the 2009 case. Now, if I had the 2014 case, I'd say, oh, great, another judge got rid of one of my cases, lucky me. But is that proper? Is sort of, he's saying it's not proper, that's the end of the story. I'm saying it's a weird procedural thing, but is it okay?
Agreed that it's weird. But to address the question, there's many answers to it. One of them is that this was an ex parte proceeding in that it was referred to the ex parte judge, who at that time was Judge McMahon. So at that time, she became assigned to the matter on the 2009.
Just for the purposes of having the Travers hearing.
Exactly. And to address Judge Renwick's question about there being other proceedings with conflicting orders, that comes from the Reimer case, which actually was posited by the appellant. That is a completely different set of fact pattern, and in this instance, there was no prior conflicting order, so it would not conflict with the 2014 order. And to address the court's question, there was actually a consolidation requested by the plaintiff on this case in the 2014 case, and there was also a consolidation requested by us.
There's no affidavit of service on David Cohen for the 2009 action. It's only the 2014 action, which is why you consolidated so that it's basically one action now.
That's correct, Your Honor.
We're meeting with the 2009 action.
That's correct, Your Honor. The reason that they actually commenced the 2014 action, which is a strict foreclosure action, was because they were unable to obtain service on Mr. Cohen, so they had to commence a new action and then consolidate it into each other.
But they never formally got consolidated.
Not formally, Your Honor, but if you read the transcript, which starts at 516 of the record, towards the end of it, Judge McMahon actually addresses it by saying that consolidation would be moot because the 2009 action was discontinued or dismissed with prejudice by the plaintiff. Therefore, the only action that this order could, I mean, she doesn't say it, but the only matter that this could be addressing would be the 2014 action.
I mean, to make it simple, the way I look at it is that was David Cohen served in either action? And the only affidavit of service we have indicates an address that even Judge McMahon said nobody even talked about. I mean, he was served at an address that...
It was a Manhattan address.
A Manhattan address on 10 East 29th Street, and Judge McMahon at the end said, there was no testimony on the East 29th Street. And this guy says, I live in the Bronx, Brooklyn. He's lived in Brooklyn.
Brooklyn on Atlantic Avenue, that's
Right.
correct. So, no, there was no testimony. There was no testimony from the process server. There was nothing put into evidence by the plaintiff whatsoever. I think the only objection on the record by the plaintiff's counsel was an objection to the admission of the proofs from the defendant of where he resided. And that was the only thing. There was no objection whatsoever. There was no opposition to our order to show cause. There was no objection placed on the record at the time the Travers hearing began asking for an adjournment because they can't get their process server here. There was never any admission of a subpoena or anything else that would indicate that they wanted more time.
Well, that objection was the bank records because the objection was that what was produced was August 27 to September 28, 2014, and then what was next produced was December 27, January 26, 2014. What you're missing here was October to November 2014. But the addresses for both what was produced were the same, so presumption is that that middle part that's missing has the same address.
Right. In the short period of time that we had to put the motion together, but I know that's not an excuse for the lack of evidence, but what I'm saying is we're showing continuity in that the date before and the date after this person was residing there. When we're filing these motions in many different courts, there's really no clear guidance as to how much evidence is required. And so we're met with kind of a conflicting decision about what we should produce. And so we felt as if, as a legal matter, that it would be prudent to show some continuity there. And so at the end of it, again, there was no process server, and it's as a matter of law, they did not sustain their burden, because once there is a traverse hearing, the onus is on the plaintiff to demonstrate that there was proper service, and clearly in this instance there was not.
Thank you. You have 2 minutes.
So, I mean, really on appeal, what the analysis is restricted to is what is on the record, not
I have a
what.
question to ask
Yes.
you. You know, when I applied for a mortgage, I had to whip out so many IDs to prove how I am. You got the wrong guy's name. The guy's name is all wrong. How is that possible? I mean,
He's not the borrower. He was never the borrower. So Albert Morales, that's actually key, and that is in the record. Albert Morales is the original borrower.
Right.
So Albert Morales, back in 2008, no mortgage payments have been made since the default date in 2008. After Albert Morales, a few months after he gets his mortgage, he defaults. Curiously, a few months thereafter, he transfers quitclaim deeds to this individual named David Cohn, Cohn David. And the address is, I believe, 173 Street, Jerome, all in the deed there, that's where he was served. How much? Testimony is clear. How much did he take the property for? A few $1,000s, which for a Manhattan property, I think to saying that consideration would be lacking there would be pretty eye-opening. So that's why in my respondent brief, there are a lot of things that, per the testimony and per the facts already, are very curious, which lead to, I think, the presumption that the reason that my client was unable to serve Mr. Cohn is because Mr. Cohn was very deftly evading service
well, that's
until...
why you needed a process server and some logbooks, because at that point in time, you're asking us to just guess that, oh, you know what, you got the right guy. Well,
Right.
that's why you say you subpoenaed the process server, he didn't show up, which
Right.
kind of raise a lot of alarm bells in my mind, because I used to sit in Part 52. You didn't get a process server coming in, and you're like, well, that's a little problematic, don't you think? I mean, here we're just going to, it's on blind faith that we got the right guy. Even
No, I agree it would be problematic, but given the length of time, given the length of time, 10 years, the idea that some person would be employed at the same place for 10 years, I don't think it's out of the realm of possibility. Now, should they have had a process server? We weren't the firm at the time, yes, but I don't think the decision is case dismissed. I think the more appropriate thing would be, and what we're asking the court to do, send this back, open up the time for us to serve Mr. Cohn, and let's litigate this on the merits rather than service a process. We know where the guy is now.
Thank you both.
Thank you.
Jagdipal versus Chamble.